The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about how to update your estate plan when you remarry. So this is estate planning for second, third, or fourth marriages. An estate plan consists of a will and a trust, or one or the other, that will provide for what happens to your assets when you pass away. It also consists of powers of attorney that provide for who will be responsible for managing your affairs if you become mentally incompetent. However, in addition to that, it's taking a look at how your property is titled, who's listed as beneficiaries on your retirement accounts and life insurance policies, and just making sure that if you become mentally incompetent or pass away, that both you or any children from a previous marriage are taken care of, or your new spouse, whoever you want to inherit your assets, is going to be taken care of. So first, you're going to want to update your will. If you had a previous will, make sure that you remove your ex-spouse from the position of executor, and that you don't have your ex-spouse inheriting your property anymore if you don't want him or her to, which I assume you probably don't. The executor is the person responsible for managing the distribution of your estate when you pass away. So you basically just want to make sure that the right people are going to be inheriting your estate when you pass away. This might be children from a previous marriage, it might be your new spouse, it might be some combination of those, and you want to make sure that the right person is in charge of that. You also may want to consider a trust. This is especially important for people with minor children from previous marriages. If you have minor children from a previous marriage and you pass away, then your ex-spouse is likely to become their guardian. And if that happens, then your ex-spouse is going to have control over any assets that are left to them in your estate. So if you have left them anything, your ex-spouse is going to be the one in charge of managing those assets until they become adults. And that's probably not what you want. But with a trust, what you can do is leave assets to your children or for their benefit, but put someone other than your ex-spouse in charge of managing those assets and distributing them. This might be your new spouse, it might be someone else, but at least you don't have your ex-spouse getting control of all of the assets that you intended for your children. You may want to also consider a prenuptial or postnuptial agreement. In addition to making any potential divorce a lot less messy, complicated, and expensive, a prenup or postnuptial agreement will allow you and your new spouse to contract for what will happen when the second of you passes away to your assets. So if you have children from a previous marriage, you can each ensure that those children are included regardless of which spouse passes away first. You can also ensure that your assets or specific things go to your family after the second spouse passes away, and that not everything goes to the second spouse's spouse to pass's family. So just think of this scenario. You're married, you pass away first, everything goes to your spouse, which is probably what you want to happen. But when your spouse passes away, you don't necessarily want his or her family or his or her children from a previous marriage to inherit everything. You want to make sure that something, a fair amount, goes to your family or your children from a previous marriage, and a prenuptial or postnuptial agreement is the best way to accomplish this. Just doing it through a will or trust can allow you to keep any assets that you keep separate. A certain percentage of those can go to your children, but you may want a scenario where your spouse gets everything during their lifetime, and after that, some of the assets revert back to your family, or a certain percentage revert back to your side of the family, and that's what a prenuptial or postnuptial agreement will allow you to do. The only difference between a prenuptial and postnuptial agreement is whether it happens before marriage, a prenuptial agreement, or after marriage, postnuptial. Otherwise, they basically mean the same thing. Make sure you update your beneficiaries on life insurance policies and retirement accounts. You certainly don't want your ex-spouse on there, but you may want your new spouse on there. You may want that all to go to your children from a previous marriage. So however you want things to be when you pass away, make sure that that's updated. You may want to consider children from your new marriage as beneficiaries. Check the titles to your property. So look at real estate and bank accounts. Any property that's held jointly with the rights of survivorship will automatically pass to the other owner without, regardless of what is said in your will or trust. So if it's just titled the wrong way in your account, you might be in trouble. So just make sure that your accounts and your real estate is titled in a way that makes sense for what you want to happen. Revise your powers of attorney to make sure you list your new spouse or someone other than your ex-spouse as your agent for power of attorney. You will have a whole new side of the family that you may want to include on this. Your agent for your power of attorney is the one responsible for managing your healthcare decisions for a healthcare power of attorney and your financial decisions in a financial power of attorney if you become mentally incompetent to do so yourself. So you've probably got a new person when you remarry who you want to be in charge of those decisions, so you're going to want to update that on your powers of attorney. Finally, account for your personal property. The default rule is that your surviving spouse will generally get the possessions in your home when you pass away. But some of these might be family heirlooms that you may want to go back to your side of the family or to your children from a previous marriage. So if you don't want your spouse to get all of the personal possessions, what you want to do is detail in your will which specific items of personal property you want to go to a particular person, and you can make sure that heirlooms go back to your side of the family. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in several areas of law, and we have several geographic locations for your convenience. If you found this helpful, we'd love it if you subscribe to us on YouTube, SoundCloud, or Apple Podcasts, or however you listen to your podcast or watch your videos. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.